morning, everyone, or good afternoon, depending on where you're based. Hopefully, everyone can see the presentation up on the screen. If you can't, for any reason, please send me a note on the chat. I was having a little bit of difficulty uploading or getting the file to show. So I think we have it now and can get rolling on today's discussion of compliance plans. I'm Kelly McIntosh. I'm based in our Reno office, but work with clients throughout our offices and throughout the country on their federal healthcare issues. Today we're going to be talking about compliance plans, some new, some not so new topics, and some things that if you've had a compliance plan should be helpful reminders or items to revisit next time you review your plan. As a roadmap of what we'll be going through today, we're going to talk about why compliance plans are important and also compliance generally, how to determine for your practice setting the issues you should specifically be focusing on, and how to determine your risk areas, guidance on drafting or updating your compliance plan, including elements of a compliance plan, and then most new to the discussion of compliance programs and compliance plans is some recent guidance both from the OIG and DOJ that's really focused on how to determine if your compliance program is effective, and a definite shift in those government authorities' view on just the form and document of your program, moving now toward more a focus on, is that program effective, and can you demonstrate that it actually is making your organization more more compliant in its application. As a few preliminaries, following the presentation, we're going to send out a copy of the PowerPoint slides. One of the OIG's sample compliance program guidance documents, the OIG's promulgated those for several different types of practice settings. We're going to be sending over the individual and small group physician practice program guidance. Also the recent OIG guide, resource guide on measuring compliance plan program effectiveness, and the recent DOJ FAQ on evaluation of corporate compliance programs. So you'll have those two resources to save and revisit as you're looking at your plan. This presentation will also be recorded, as all of our webinars are, and available for you to view later on the Holland and Hart Health Law blog. If you have any questions, feel free to use the chat during the program or email me directly. Given the time constraints, we may not have time to go through questions during the presentation, but if you send them on the chat, during the chat, they also come up later, so I can respond to them. I get a summary of any questions submitted, so can respond to you separately after the program. And then if you have any issues during the technical issues during the program, Luke Kelly is on the line and available, so just reach out to him and we'll try and resolve those for you. Generally, with all of our webinars, we're just providing an overview of legal considerations here for your compliance plan. Compliance plans as a general topic definitely are not one-size-fits-all, so many of the things we'll be discussing may have some applicability to you, but definitely need to be looked at on any of the topics we're talking about for your specific size, practice setting, resources, several different considerations. We're just going to be giving an overview, so we don't have an attorney-client relationship, and this program does not constitute the giving of legal advice. So with that, we'll jump into the program. So without compliance, you're definitely at risk of, and I like this, the thin ice analogy, without a compliance program and active compliance activities, everything may look good on the surface, but you're just one wrong step away from a crack that could, in theory, take down or be very disruptive to your whole organization. So compliance programs are an especially helpful tool to make sure that you're not just kind of going along with everything looking fine while there are risks and dangers out there that could occur at any given moment. Risks, if you don't have active compliance activities in your organization, include enforcement actions. I'm sure many or all of you have seen headline-making reports about the activities under, False Claims Act, civil monetary penalties law, criminal actions under some of the anti-kickback and related statutes, exclusion from federal health care programs, things that can definitely be pretty substantial, if not an end type event for ability to practice, at least in the federal health care systems. Duty to self-report and make repayments. There is now an affirmative duty to report overpayments and repay those overpayments. With a compliance program, you're going to have that process and the ability to effectively and appropriately make repayments, hopefully much more effective and efficient for your organization. Another risk if compliance is lacking is a key TAM action, whistleblower actions, where someone potentially in your organization alerts the government to activities that are going on and can pursue an action against your organization on by that route. And also the risk of audit. So both the risk that will occur, and more importantly, audits can occur routinely, and that can be a fine activity, and actually part of the compliance program includes auditing activities. But the risks of not having an effective compliance program are that those audits will reveal significant issues, and especially issues that may have been able to be prevented or mitigated earlier than when they were caught. Additionally, fines and settlements. Again, those are often the headline-making type items. And along that, harm to reputation, even if it's something that's resolved without significant fine or monetary effect on an organization, just the reputational harm of possibly making the news, reaching a settlement agreement with the government that's then public, can have significant impact in and of itself. Operational interruptions as you're dealing with both an investigation and then potential remedial action following that. Lost profits as a result of many of these things kind of all accumulating together. And just to put a little bit in perspective of how active the government is and continues to be in terms of going after fraud and abuse actions and things that all could relate to compliance activities. Last year, the OIG reported that the government recovered over $3.3 billion, and that came from a variety of activities, but making up the activities were 765 criminal actions, 690 civil actions, and over 3,600 exclusions. Those numbers have also been fairly constant or in the same type of range over the last many years in terms of the number of actions and exclusions. So each year there is a significant amount of activity criminally and civilly in this arena. And this year alone, now that we're just a bit over halfway into the year, there have already been over 40 new corporate integrity agreements between provider entities or individuals and the government. So this year's looking like it's going to be on a similar path of enforcement activity and resulting recovery, corporate integrity agreements, and the like. So do you really need a plan? Yes. One thing that did want to just touch on briefly, though the ACA is, the shape that some of this may take in terms of enforcement and applicability going forward may be a bit unknown, but Section 6401 of the ACA requires compliance plans for providers across industry sectors as a condition of enrollment in the federal health care programs. And there was a specific section that also required skilled nursing facilities to implement and adopt their plans by March of 2013. So that's now been in effect for several years. The implementing regulations for the Section 6401 requirement were not issued, so that requirement still stays somewhat in flux. My personal opinion, just based on the track that the government continues to keep with its enforcement actions, its investigation actions, its I think strong motivation to recover funds where the government can do so in the healthcare arena and specifically focused on fraud and abuse, I would strongly think that compliance plans are going to continue to be something either mandated or continuously and increasingly looked at as a function of what a government agency will look at when investigating a provider for a host of issues in the fraud and abuse arena. So whether there's a specific mandate, I think that could still remain likely in any future lawmaking. And beyond that, having a plan, I think, will only serve to help a provider if you come under investigation. So would definitely recommend, if you don't have a plan, that you get a compliance plan in place. Hopefully many or most of you do have plans already. If you haven't revisited them recently, definitely suggest that you put that on the next, as an action item for your organization on your next annual review of policies and procedures and that type of thing. And as I mentioned, we will be sending out the physician practice guidance that the OIG promulgated for compliance plans. The OIG has also put out guidance for these types of providers as well, so from hospitals to nursing facilities to billing companies. So hopefully your organization either falls within one of these categories specifically or is similar enough that some of this guidance might be helpful for you in putting together your plan. And I'd suggest that you just search, the OIG's website has the links to all of these. They're PDF files that you can download. Additionally, Medicare Advantage managed care entities and prescription drug plan entities also have mandatory requirements to have compliance programs. So those are not new requirements, but they're two types of entities and organizations that are also required to have compliance plans. A few other reasons to have a compliance program. It definitely demonstrates both internally and externally that you're committed to compliance and that that's the culture that you're trying to build in your organization. It can reduce your risk of an audit, can minimize the requirement to have a CIA, a corporate integrity agreement, entirely. That's a potential, or at least could minimize the impact that a CIA has on your organization. Can be a mitigation factor in terms of the penalties assessed after a government investigation, can reduce your threat of whistleblower actions, and again, internally just helps in your organization to let individuals know that compliance is important and that they need to be an active part of compliance for your organization. It's also just good business. It can help minimize chance that you get claims bounced back, denied. It can improve your documentation and make for more consistency throughout your organization. And it's, especially in the healthcare world, I like to use the analogy of it's, kind of the preventative medicine for your business, for your organization. So the regular checkups that providers recommend for their patients, this is the regular checkup recommended for the providers. So one of the first things in setting up a compliance plan or revisiting a plan you already have in place are identifying specifically the risks that your organization faces in terms of compliance. So your practice, your organization will have specific types of risks that'll in part be dependent on the size of your organization, how many locations you have, how many employees, how many different types of providers or et cetera you have, also the type of services you're providing. And again, the OIG compliance guidance is a very good starting point because in each of those various guidance documents that it's issued, it goes through for each of those provider types some of the common risk factors. In the physician practice guidance, some that are called out are documentation, billing and coding, and improper inducements. So the OIG breaks down different risk factors and then also discusses beyond that certain compliance activities and pieces of your compliance program that can help address those risk areas. So how often should you revisit your risks or revisit your plan? In general, each year is a good rule of thumb, and that's been my suggestion to clients for years now based on some of the earlier government guidance put out, and also just being something that I think is feasible and you know, something able to be calendared, et cetera. It kind of operationally just makes it an easy thing to do yearly. That's now actually been heightened by the recent OIG guidance that I'm going to go into a bit more later. They actually talk about more specifically that each year is a good time to revisit this. So definitely can do so more than annually, and sometimes that may be the case. If your organization goes through an acquisition or adds a service line or has some kind of material change or event, that probably also is a good time to make sure that what you have in place works as your organization's changing. But if you're not having those big changes, at least annually, just put that on your list, you know, calendar for a time of the year where it's appropriate, and have your compliance, your compliance officer and your executive team involved in that process to revisit and update your compliance plan and your risks. As you're doing so, I would also suggest some areas to make sure you're looking at for risk considerations are the OIG's annual work plan. I put the link in the presentation, and the OIG issues that annually to indicate the areas that they're focused on in where they're looking at things in the fraud and abuse arena, for instance, or where they're looking at recovery actions. So if the OIG has indicated that year that coding or specific areas of coding are a focus for them, that's probably a good focus for you as well if that's something applicable to your organization. So it's a good heads up as to where the government is going to be looking, and as a result, you know, where you want to make sure you're as compliant and clean as possible in case the government comes knocking at your door. There's also a recovery audit contractor approved issues list that's issued annually, and they're also, you can find for your state programs, almost every state's Medicare or Attorney General will issue similarly a report of their recent activity, usually looking back for the prior year, but some of those resources also can help you just get a better focus and handle on where the government sees issues and, you know, therefore where you may want to make sure that you're reviewing and trying to minimize your risks. And also, finally, on kind of risks, don't forget your internal sources. So if in the past year when you're looking back, you see that you've had a host of either complaints or a common theme come up from staff interviews or things that have shown up in audit reports, especially if there are, you know, multiple occurrences of one topic coming up again and again, that's a very good indicator that that should be something that is a heightened focus in your compliance program. And those are the types of items that if you fail to address will look very bad in the eyes of the government potentially if they see that you had, you know, 5 complaints on a topic and the organization did nothing about that in its next annual review. That's not going to look very good. Conversely, addressing that and being proactive on trying to minimize whatever that area of concern is will show that you're, you know, actively engaged in compliance. So for your compliance plan, there have been for probably 20 plus years. I think now these first came out in the mid-90s. With the federal sentencing guidelines. There's been 7 fundamental elements that compliance programs should address and should focus on. So the first is implementing your compliance standards. That's all your policies, procedures, standards of conduct, often the written type items. Making sure that you've designated a compliance officer or committee. Conducting training and education, so usually on those items that were in number 1, then actually rolling them out to your workforce. Developing open lines of communication. Conducting internal monitoring and auditing. Enforcing your standards through well-publicized disciplinary guidelines and taking disciplinary actions as appropriate. And then promptly and appropriately responding to detected issues, including corrective action. And again, these first came about through the federal sentencing guidelines, which were issued in determining how sentencing of organizations would occur in criminal violations. One of the components there was that an organization received credit for an effective program to prevent and detect violations of law. And that's then become sort of the standard for compliance programs. And of that definition, and the big piece there is effectiveness. Just having the binder on a shelf that is your compliance program means very little if it's not something that's actually effective and implemented in your organization. And these elements can't exist alone or should not exist alone, so all 7 of the components need to be implemented effectively and together to have a compliance plan that's actually working. Some of the things that the government definitely looks at is the commitment to all of those elements. So that doesn't mean, especially if you're a small practice or a new organization just starting up, that you have to plan to have a compliance program that's on the scale of a regional healthcare system. It just means that you need to have something that is appropriate to ensure compliance in your organization. That could mean that you're implementing things over time and incrementally, but you should have a plan for how you're rolling things out, how you're developing your compliance program, and that ultimately you're going to have a program that's effective in your organization. And definitely don't approach it as something where if you don't have the resources, it should be all or nothing. If you have resources to get policies in place, do some training in the first year or first 6 months, and then have a plan for doing additional training 6 months down the line. Take the step-by-step approach. Do as much as you can to implement your program every step of the way as you're either starting an organization, building an organization, or just rolling out compliance in an existing organization. And one good way, if resources are at issue, is to participate in other organizations' programs or to have your workforce utilize training and activities that perhaps aren't sponsored directly by you, but still serve to get the information to your employees. So, even sending out copies of OIG and DOJ guidance, or finding resources, webinars, things even along the lines of what we're talking about today on topics that address compliance. Don't have to be costly, but at least get the information and the guidance into the hands of your workforce. So the first element there, I'm just going to break down each of the 7 a bit and talk about how you can implement those and what the government will be looking at in determining if you have an effective program. Your standards, policies, and procedures. So the code of conduct that would be part of this element is actually different from your policies and procedures. The code of conduct is usually pretty short, and it's a statement that sets forth the ethical attitude of the organization. It outlines the duties and goals of the organization, and is something that could be hung up in a break room or distributed with new hires, entry paperwork. It's something that everyone in the organization should be familiar with. Maybe can't recite word by word, but should should know that that code of conduct exists, and it hopefully reflects the culture of the organization and your commitment to compliance. Then actually getting into specific policies and procedures, these will break down more specific areas within the organization where compliance would be considered. So often would have policies and procedures on billing and coding, improper inducements, kickbacks, self-referrals, HIPAA and high-tech and other privacy and security considerations, record retention policies, all the things that really break down topic by topic what the standards and requirements on the various elements of that your organization has and needs to be compliant with regard to, breaking those down in a way that, again, people can find easily and should be something that they can reference, but these would be items that might more be centralized on an intranet or in a larger volume that would have reference to these specific topics. They also could carve out, your policies and procedures could also carve out other elements of the compliance program. So though we're going to get into in another couple slides, internal reporting and auditing and monitoring as components of your compliance program, those types of items may also actually have policies and procedures. So you may have a written policy that indicates the different mechanisms by which an employee can report a violation or report an issue, or the process for investigations within the organization. Definitely want to have these in writing, reduced to writing, both so that it's clear what your policies and procedures are, and you can then hold people accountable and make sure that they know whether they have or have not complied with that policy. Also can show when those have been updated. So you can, definitely have dates on them that indicate that they're current or when they were last revisited. Everyone should know, on your workforce, should know how to access those items, whether, again, it's an electronic format or a paper format. Because you want your workforce to be able to implement and understand the policies and procedures, try to avoid complex language, try to have them be as user-friendly as possible. I often find using examples where you can and where appropriate is helpful, because that can remove ambiguity of just a written statement if you also then break it down with an example of what that means. And as with your program in general, don't let your policies and procedures collect dust. Update them as appropriate. Again, annually is a good rule of thumb. Dating them definitely can be helpful to have the understanding of when those were last reviewed. There are certain things as well. Again, save for the annual review, there might be changes in law that would impact and require updates to your policies and procedures. Having the dates on them will also help ensure that everyone knows if they're looking at the policy that was in effect in that example, before a law went into effect versus after. So having the dates are also helpful from that perspective of anyone looking at a policy can quickly know if it's the one that they're operating under now or something that's outdated. You should definitely identify also who's responsible under each policy, so who needs to be following that policy, and who is the one in charge of either updating or implementing that policy, so that if your workforce has questions or needs to confirm if they're doing something right under the policy, that they know who they can go to, whether that's an individual or a title or a department, just somewhere that can give your workforce resources to ensure that they're acting compliantly. And definitely make sure that your staff and workforce are educated and understand the policies and procedures. And to either distribute, or if it's an electronic access, give some sort of an acknowledgement that your workforce has reviewed and received and knows how to access the policies and procedures, so that you have a way to ensure that there's not an ability to say, I didn't know that existed, or I didn't know we had that policy. Some affirmative step that will have your workforce engaged in the process of understanding the policies and procedures. Next element is a compliance officer and or compliance committee. This depends, whether you have an officer or a committee or both will largely depend on your organization's size and type. If you're a solo physician practice, probably going to have a compliance officer, have an individual that's designated in that role. If you're a regional health system, probably will have a chief compliance officer, but also will have a compliance committee, may have several subcommittees, may have a whole compliance arm that's appropriate for that size of an organization. And sometimes then, the types of subcommittees that a larger organization may have would be audit committees and enforcement committees. Both of those usually would be standing committees, though sometimes they don't need to be meeting consistently if there are no ongoing audit or enforcement actions, but a group or a committee that could reconvene when such a need arises. So generally, a compliance officer or the compliance committee, the duties would include helping or being the key lead on developing and updating policies and working with the people in the organization that can speak to the specific areas of the policy to make sure that they're up to date, are operationally effective, so working with people in the organization to come up with examples and make them user-friendly. The compliance officer would be in charge of training, so whether that's ongoing general training, targeted training after either a change in a policy, change in law, a target because there's been an investigation, subsequent result that sounds like the workforce needs further education on a certain topic. And with that as well, though many times definitely you want your employees and people that are directly in your control to be aware of your compliance activities. Make sure that independent contractors and others who are providing services to you are also aware of your compliance plan and all of the activities. Compliance officer serves as a point person for complaints and investigation, and independence is important. So often trying to have that person, the compliance officer, not serve multiple hats necessarily. Again, depending on the size of your organization, that may or may not be completely feasible, but having a compliance officer that is an independent or independent person in the chain of reporting can definitely increase effectiveness and promote buy-in, because someone on the workforce, even at a lower non-supervisory level in the workforce, should still feel able and encouraged to report to the compliance officer if they see issues in the organization. Training and education is the next component and factors right into what the compliance officer will be leading. So who should receive training? Everyone. That goes from the top down, and again, even to independent contractors and third parties dealing with your organization. So the management and board is definitely an area that should have training, and sometimes I think is not quite as much of the focus as training a category of employees or new hires, that sort of thing. Management and the board is especially important, because having training on compliance topics at that level helps show that there's a culture of compliance from the top down. Also, make sure that you have outside parties receive training, or either from you or evidence to you that they have their own compliance training activities ongoing. That can include also third parties you work with, maybe like a billing company, outsource service of various types, especially if they're a third party that deals with anything that is in your claims or billing process, anyone that your organization ultimately is submitting, anything to the government and saying that it's accurate or you're receiving reimbursement for, you want to ensure that that has been done compliantly. So in general, some of the instances where you'd want to do training would be, upon hire. New hires should definitely receive training on your compliance plan generally, specific topics like privacy, depending on their role, billing and coding potentially, or documentation, host of different types of topics. If you have not implemented a compliance program and are just doing so for the first time, definitely would want to do widespread training for everyone upon implementing a compliance program. Annually is good, especially if you can set aside a day, part of a day, to go over any updates to your compliance plan, to highlight changes in law that have come up that year. Obviously, if you have the time, ability, and if there's a need, if there's a significant change in law or if there's an issue in the organization, do so more than annually. But annually, again, is a good rule of thumb just to make sure you're staying active and engaged in compliance. And you do want to maintain training logs. That will be very helpful and important to show that you've been working on this element of compliance, especially if you are subject to an investigation. So going back and touching on the board and senior management a little bit more and why it's important, they also have, do have training and education and realize that they're an important part of the compliance program. Is ultimately they are responsible for the compliance program. So a compliance officer may be designated, there may be a compliance committee, but it's the board and senior management that are ultimately accountable when the government is looking at an organization, and that's whether or not they're aware if there's non-compliance occurring. So, and the government's view and why they look to board management is that the board and senior management are the positions within an organization that are often able to prevent and correct issues. And if they fail to do so, and we're in the position where they could have, the board and senior management may be held liable even criminally by the government. And there's also CMS guidelines where they've issued in the Medicare manuals for certain provider types, the governing body and senior management rules and compliance and what that should mean in terms of those capacities working to drive compliance of the organization. The next item is reporting and communication. This is how you'll get information through the organization that indicates where there may be compliance issues, areas to strengthen. You need to have in place mechanisms for reporting. So internal versus external, meaning, do you have a hotline or an email address where people can send compliance concerns? Is there something externally as well? Is it just internal? Is there also a way outside of the organization that you can receive information? Having a non-retaliation policy is very meaningful and can be helpful in encouraging reporting and communication to happen in your organization. Also, if able, giving an element of confidentiality or anonymity. There's some that can cut slightly both ways, in that you may have more willingness for your workforce to report issues if they feel like they can remain anonymous and have confidentiality. But there also might be instances where that only goes so far, because at a certain point in doing an internal investigation, then you need to ask additional questions, you need to follow up, and some of the level of anonymity can't remain. So just need to sort of balance that based on your organization and the issue at hand. And also exit interviews. So when people are leaving your workforce, getting input from them as to, any items of concern that they have, things they think your organization might be able to do better, definitely can be items that you can build on and use in increasing the effectiveness of your compliance program. For open lines of communication, here's a couple suggestions. Try and make your compliance officer accessible. Using a reasonable person standard, so require reporting for conduct that a reasonable person would believe erroneous or fraudulent, and have it be a user-friendly process if you can. So, could be a call line, Dropbox, might be just a, compliance, a web, or, an email address, compliance@yourorganization.com, something where, you can get info up the chain of the organization quickly, effectively, and make it easy for the members of your workforce to do so. In reporting and communications, investigations are also part of that component. Investigations should have a process. You should have, there should be a method by which you conduct your investigations. So define that process in a policy, whether, how that starts, who leads it, what that process looks like, what ultimately the outcome should be if, if it's a written if there are different options, written investigation report, description of corrective action taken. Your policy should just walk through all of the elements of an investigation. When you're going into an investigation process, consider and keep in mind the attorney-client privilege considerations. There may be things that you want to definitely ensure that you have an attorney involved in and directing so that you can have that attorney-client privilege. Confidentiality, again, and anonymity, excuse me, goes hand in hand a little bit in this process as well as to, how much can you guarantee or tell someone that what they're telling the organization is going to be kept confidential, knowing that, it could be something that you need to investigate further, might lead to needing to make a report to the government, et cetera. And then ensure that investigations, and both during the process and the outcome of an investigation or the conclusion of an investigation, are reported up the chain to leadership. Monitoring and auditing is the next standard, and those are two different functions. So monitoring is the ongoing self-review, where you make sure that your processes, as they are continuing to play out and go on day to day, are compliant. That's not usually independent. That's just usually done more by internally, kind of checks and balances of, did we run our excluded persons list this month? Did we, have the training on HIPAA that was planned, that we have every second quarter? Auditing, differently, is usually, or it's objective and often independent, typically at an area for the purpose of finding factual results. So, an audit of your documentation, a sample of charts that are then audited to make sure that your documentation processes are consistent, contain all the necessary elements, et cetera. So both of these processes should be ongoing in your organization, but monitoring is something that is sort of, day in, day out should be occurring. Auditing is more focused on looking at a specific topic and then reporting if it factually is occurring correctly, incorrectly, room for improvement, et cetera. A baseline audit is helpful for many organizations because it will let you know where you're starting from. So after you've rolled out a compliance program, sometime after that, doing a baseline audit of, okay, we trained everyone on, for example, again, on documentation. Let's do a review now to see how accurate our documentation looks. Concurrent versus retrospective audits, that's whether you're talking about something that's ongoing currently or back in a period of time. Retrospective audits can be very helpful because they do give you a specific time frame to report on, but they also don't necessarily reflect the current status of your organization today because by their nature they're looking historically. So Both types of audits can serve different functions. Whether you do those internally or externally, have an independent party or do you run them internally. And with both monitoring and auditing, it in many cases can be helpful to share results. Can sometimes make those watered down a bit so that, or not watered down, but redacted or, not with names and identifiers. So high-level reports of what the results included, just so that the organization in general knows, here's our risk areas. We, as an organization, could be more compliant or we have some, areas to improve in our documentation in this area versus looks like we're doing very solidly in, this other area. And a couple areas to monitor, as I mentioned, excluded persons list. That's very important and should be an ongoing activity for the organization. And physician relationships. You can often, I have many organizations I work with that have, where we've set up checklists of, anytime they're entering into a contractual relationship with a physician that has a financial relationship and could trigger things like Stark and anti-kickback, a checklist of making sure that they've considered all the other relationships, that meets any necessary exception or safe harbor, it's in writing, X, Y, and Z. So things that they can monitor on an ongoing basis to make sure that they're staying compliantly in the requirements of the respective laws. Things then to audit would be things like standards and procedures. So make sure that in each of your standards and procedures you're properly implementing the requirement, for example. Claims, another definite area that is very frequently a subject of audit. OIG recommends an annual review in auditing, 5 or more records per federal payer, and 5 to 10 records per physician. And the larger their sample size, the more confidence you'll have in the results. So, definitely doesn't mean that any audit needs to be a top to bottom 100% review of all claims that year, but should be a sample that hopefully can give you, meaningful results on how your organization is looking overall. Enforcement through disciplinary guidelines. If you have something where you've determined there has been a non-compliant activity, have appropriate sanctions for non-compliant behavior, make sure that those are applied consistently, and have established and documented in your policies and procedures levels of severity, but also do allow for flexibility. So, don't make something, there are some things that will be black and white, but not everything will be black and white, I would say. So if you find yourself in a situation where there's been non-compliance, your policy says, up to and including termination could be the sanction. If you're recommending something less than that, and there's a good reason, and there's a reason why that was the conclusion of the investigation, just document that. Document so that in a year or two, if you're investigated or if your compliance officer's changed and, people on the workforce may or may not be there any longer, there's some record as to why that was the result in this action. The OIG, indicates that you should set forth expectations, identify what constitutes non-compliant behavior, list possible disciplinary actions, and if it's intentional or reckless behavior, that might be a factor that definitely could, may support a stronger disciplinary action than if it was unintentional or, not reckless in the behavior. So definitely, if you detect non-compliant behavior, also try and correct the problems. If it's something that can be corrected going forward, determine if you have to make any repayment of overpayments or any other government disclosures. Perhaps you want to voluntarily roll out a corrective action plan that would help your organization have measurable standards for if you're correcting the issue. Focus on your monitoring of that issue. And again, kind of all of these document to show responsiveness. So your compliance plan. Again, compliance plan is compliance is a process, so continuously review that. Make sure throughout your organization everyone's aware of the plan, assess it for effectiveness, assess it for new risks, and commit adequate resources to compliance. Having an ineffective or outdated plan may be worse than not having a plan at all. That also has been kind of an ongoing piece of advice I've given. That's been highlighted again by the recent OIG and DOJ guidance. And that, again, the recent guidance for both of those organizations has been, if you have a program but it's not effective, that is not going to be a helpful fact for your organization. So may actually look worse for your organization if you have, if you at some point in time said, oh, we should be compliant, this is what that's going to look like, and then just never followed through in actually implementing those things. The new guidance that the OIG and DOJ issued is helpful, I think, as very good resources that every compliance official should have saved on their desktop or somewhere handy to just run through, because it actually gives one of the clearest looks we've had so far into what government investigators are going to be asking and measuring in terms of your program's effectiveness. The Department of Justice FAQ has questions. It's only about 8 or 9 pages, but it has questions in 11 categories. And they cover, as you can see here, kind of the 7 elements of a compliance program, and then some, kind of some subsets of those. But they don't necessarily give you answers, or I mean, they're FAQs, so they give you questions. But the thought would be, if your organization has run through all of those questions, or at least the questions that apply to your organization, that should put you in a very good position if an investigator comes through and asks those same questions, that you've got an answer, that you've thought about those topics for your organization. So again, I think it's actually set up even as a kind of a checklist. There are little boxes that you can literally, possibly as part of your annual review, just say, okay, let's run through this, the checklist. Have we considered all these questions? Are there things that have changed since last year? How would we respond if the DOJ came, knocking on our door tomorrow and asked us these questions? And then the OIG's resource guide, that is a bit longer. It's over 50 pages, but it is a very significant resource going through those 7 elements. So it's got separate individual effectiveness measures for the 7 elements. I believe there are over 650 in the document measurement standards, and these are going to be actual metrics that, in theory, the government could look at, and coming together and trying to put a picture together of if your organization is compliant or has been acting to achieve compliance in these various components. It breaks it down, again, though it's a longer document, pretty user-friendly. I would say it's also something that, again, we'll be sending this out with the program following the webinar today, but would suggest your compliance official and senior management review the whole document, read through the 50-plus pages, at least, the first go-round, identify the areas that are very applicable to what your organization does, your organization size, et cetera, and then use that as something to go back to, annually or more so if able, to make sure that you're continuing to consider these different elements. This, again, does also focus on that it's not one-size-fits-all. This should be, the metrics that are contained in the resource guide should be applied to your organization based on your risk areas, size, industry segment, and things that may change from year to year. A couple things that I thought were interesting from that were specifically that there is, in many of the different elements, there's a focus on bringing external input when appropriate. So whether that may be for investigations, for auditing, for training, administering your compliance program. So not just keeping your compliance activities internal. And I think the thought is twofold, and the motivation for that. One, you're going to have more independence potentially, meaning that people in your workforce may feel more comfortable dealing with a party that they don't report to directly day in, day out for other work activities. And the third party will have a fresh set of eyes. They, things that may have become so commonplace that no one in the organization really thinks of them as issues, someone externally may come in and say, oh, wow, that's how you're doing things here. That's a big risk, or we see, a way maybe you could do that more efficiently, more compliantly, and that's something that the external source will give you as well. Additionally, external sources like attorneys, compliance professionals, they may have both, with attorneys could have privilege type protections for your organization, and in both cases, attorneys and compliance professionals may just be in the position to stay and be more aware of current trends, changes in law, things that, since that's their world day in, day out, they can share with your organization and make sure that you're aware of those as well. The resource guide does indicate that just, checking the boxes that it has there about, do we have this metric? That's not an effective way to really establish compliance. Many of the metrics, you should really dig deeper and have interviews with staff. Make sure that key executives are aware of various topics in your compliance program. That's going to be the difference in, documenting that you've had those interviews and had that process. That's going to make a big difference in having an effective compliance program and showing you have an effective compliance program versus, again, having kind of just, the on-the-shelf compliance program that's really just gathering dust and not doing much effectively in your organization. Some of the elements in the assessment need to probably be repeated every year, or again, more even frequently than that, whereas others might just be, some you'll probably never encounter in your organization. Others may only be applicable when you have a perceived risk in a certain area. And that's why, again, going through the whole thing initially, I think, is very important for compliance officers. I think the biggest takeaways from both of the recent guidance is that the OIG and DOJ, they want effective compliance plans, something that is in your organization and throughout your organization has some buy-in. Couple last takeaways on how I would suggest you encourage buy-in in your organization. Explain, as part of the initial training for your staff, explain to them the benefits of effective compliance. You see increased efficiency. It'll make for happier patients because there'll be less issues with, everything from their check-in to receive services, to their billing, to their aftercare. The whole process will be easier for staff and patients, and it'll help maximize revenue for the organization. And then also focus on, the consequences if there's non-compliance. So, for an individual, definitely could mean employment sanctions for the organization, or an individual could mean fines or repayments. And, ultimately, one of the highest levels you try and avoid is criminal issues, which can also arise. Set the tone at the top. So, in your organization, make it widely known that the board and upper management, that they receive training as well, that they're part of the compliance process, that they're on board in this with everybody else. Have transparency. Again, after there's been some investigation or audit, give what results you can, or summary information to let people know, how they're doing, how the organization's doing, what what they're doing well, what can be improved, etc. And, devote resources, make it, in the organization, show that compliance is a priority by, having people see that there are trainings being conducted, that annually they're receiving new updates to the program. And a few of the resources I would, again, point you to in trying to get information to your workforce and putting your plan together. The OIG has a lot of resources on its compliance website. That's where you can find its work plans, advisory opinions, fraud alerts, settlements, the compliance guidance for different types of providers. Look at state attorney general actions, Medicaid fraud unit actions, compliance organizations. The Healthcare Compliance Organization is one nationally that is very focused in the compliance arena. Internet sources, but just definitely would caution you there, especially, in the day and age where things can be outdated and change within, days, weeks, months. Just always check, where kind of the source you're getting the information from, and if it's outdated. If it looks like it's something that's from 2010, may not have much relevance to that topic today. We have resources also through Holland & Hart. We have on our blog, we send out client alerts and have publications that are helpful. And we also have recorded webinars that you'd be welcome to share with your staff or workforce, or just for your own information on many of the topics that you'd want to include in your compliance program. We have the fraud and abuse laws, physician contracting, HIPAA, EMTALA, antitrust. So all in about an hour, and summaries and highlights of those various items that hopefully will be useful for your organization. So with that, thanks very much for joining. There's all of my contact info. Feel free to reach out if you have any questions. We will, again, as I said, be sending out the slides, one of the sample compliance program guidance from the OIG, and then those two recent resources, the DOJ FAQ and the OIG resource guide. Definitely would suggest saving those, distributing them to your compliance folks, if not, more broadly in your organization, and using them. They're something that I definitely think is useful, is user-friendly, and it's, nice that we now have some clearer input from the government as to what they're going to be looking at to help providers prepare and be focused on compliance and effectiveness of compliance. So thanks very much. Enjoy the rest of your day, and hope to catch you at one of our future webinars. Thank you.